hearing after we heard last week from DEC and the Agency of Ag had come to consensus on language that would satisfy both of those parties on this question of stormwater runoff as it relates to farms and permitting fees. So what I wanted to do, though, before we had any more conversation about it, was have Mike run through the amendment. We can talk about the amendment. We can talk about other directions we might go. We've got a little time for discussion. Then we're going to have Mike switch gears, as I mentioned yesterday, and talk to us a little bit about, if you have time, the Soil Conservation District statute.
Sure.
But let's start with this one.
Okay. For the record, this is Mike O'Grady, Legislative Counsel, put up on the screen and it's on your committee website. Proposed amendment to S-115 from this committee. As you may recall, in the Senate Agriculture Committee in S-115, they included language proposed by the agency that would have amended 24 VSA 4414 to say that municipalities did not have authority over agricultural operations in the same manner that the Agency of Natural Resources does not have authority over stormwater from agricultural operations. That passed out of the Senate Ag Committee, went to Senate Finance. Senate Finance asked for a recommendation from, and the reason why Senate Ag proposed that language was that farms are being assessed by some municipalities an impervious surface or stormwater fee that can be very expensive. I've heard up to $9,000 per farm per year. And the Agency of Ag wanted to clarify that municipalities did not have that authority. Senate Finance asked that Senate Natural Resources look at the issue. Senate Natural Resources proposed, instead of exempting or clarifying that municipalities don't have authority over stormwater from farms, that there should be a study, and that while there was a study, that there would be a 1-year suspension of municipal authority to assess fees on stormwater from farms. However, in that interim, the Agency of Agriculture, the Agency of Natural Resources have discussed proposed language. The Agency of Natural Resources Commissioner Beeling talked to EPA, from what I understand. And what is being proposed is to, again, go back to an amendment to 24 VSA 44 subdivision 9, which is municipal authority to regulate stormwater, to provide that municipality shall not charge a fee under that authority or under other provisions of this title, which would include municipal sewer authority for discharges of agricultural waste or agricultural non-source pollution, including stormwater runoff from impervious surfaces that are managed pursuant to the required agricultural practices. Now, the concept there is under the RAPs, stormwater from impervious surfaces in your production area is already supposed to be contained and controlled. So it's not running off into an MS4 system. And then agricultural stormwater outside of the production area is, according to US EPA, not subject to a NIPDES permit, not subject to a discharge permit. And an MS4 permit is a NIPDES discharge permit. So basically what you're saying is that stormwater from impervious surface on a production area doesn't need to be regulated by an MS4 because it never reaches the MS4. And agricultural stormwater runoff outside the production area is, according to EPA, not to be regulated. And this is to clarify only that the municipality shall not charge a fee for that agricultural waste or agricultural non-point source pollution. Now, the terms agricultural waste or agricultural non-point source pollution are used because those are the terms that are used in statute when the RAPs are created in 10 VS and 6 VSA 4810. So there was a little back and forth between the two agencies about the language, and this is what they have agreed to. And EPA has also, to my knowledge, said it was okay. And then if you're going to replace what Senate Finance put in, that 1 year suspension doesn't need to go in. So Section 9, which had been the 1 year suspension in the Senate Finance amendment, is replaced by a provision that was in the Senate Ag original proposal, that municipalities are not required to refund the stormwater operating fee to farms that were assessed prior to the effective date of this act. I think that's a policy decision, but Senate Ag discussed the equity of it and didn't want to place an inequitable burden on the municipalities that were collecting in full faith. They were not nefariously collecting the fee, not to penalize them, to require reimbursement.
John. Representative O'Brien.
What would happen, Mike, with the farms that have yet to pay? Does that fee get waived?
That's a good question. Because the Section 9 language is to refund stormwater operating fees assessed, so that would have required payment. And now, after the effective date, they can't assess. You might want to add clarifying language on that, and that and it'll be up to you whether or not the farm would be required to pay or not if they were assessed prior to the effective date.
Okay. Representative Pearl and then Representative Templeton.
Mike, I'm just trying to understand the bigger picture and how we got here. So at some point, the legislature told towns or municipalities that they needed to regulate stormwater. And because they had to regulate it, there was also in statute some Dillon's rule, the whole Dillon's rule thing, they had to give them permission to be able to get fees from everybody. Like, what was that how was that written? Like,
So, I'm going to go like way back, like in the 80s, Vermont was one of the first states to start regulating stormwater. And then in 82, EPA said all states had to regulate it. It really didn't say how. So then the state, over time, created its own state stormwater permit program. But they also created this system where the Agency of Agriculture was going to regulate agricultural non-point source pollution, which is another name for stormwater. In the early 2000s, there were 14 waters that were identified as impaired because of stormwater. When you identify waters as impaired because of stormwater, you have to create a plan to clean them up at the state level. And the state really wasn't doing a great job of that. And so what the state did is it required any MS4 community that had a stormwater impaired water to regulate that water under the MS4 permit and to bring it back into attainment so that it was no longer impaired. And in order for that to work, they had to designate certain towns as MS4 communities that weren't already. So those are the towns that are required to regulate the stormwater from their municipal separate storm sewer system. And, all right, so that's where you are with that.
Yeah.
Elsewhere in law, municipalities are authorized to create sewer districts, sewer utilities, consolidated sewer districts, et cetera. And underneath that authority, they are allowed to assess rates. In 2003 or 4, sewage under those statutes was redefined to include stormwater. So the municipality could form a sewer district, have a sewer utility, and include underneath that the ability to regulate stormwater and assess a stormwater fee. So 14, 15 towns have to regulate stormwater in order for them to, and they have to file the MS4 permit. Most of them have formed some authority underneath municipal sewer authority to assess a fee to pay for that MS4 permit. And so that's where you are with that. But within each of those provisions are exceptions. Underneath the state stormwater authority, the state can't regulate stormwater from, or A&R can't regulate stormwater from a farm. The Agency of Ag regulates that. Underneath the municipal authority, municipal bylaws, it says right there in 24 VSA 4414 that they have to regulate pursuant to 10 VSA 1264, which is A&R stormwater authority. And in that section, there is an exemption for farming. And then when you go to the MS4 permit, the MS4 permit says it applies to developed lands or to an MS4 system. Well, the MS4 permit says developed land does not include farms. And then the MS4 permit, when you look at EPA's rules, says it doesn't include agriculture or stormwater runoff. And then any other ag impervious surface runoff doesn't reach the MS4 because it's contained under the RAPs. So there's really nothing that reaches the MS4 system in these 15 towns from farms, or very little. That's regulatory within the MS4 permit. So that's really where you are. Now, the municipalities are probably going to come and say, you gave us authority under municipal utility, sewage utility to assess rates for stormwater. We're assessing rates. We want to do it equitably across all properties that have impervious surface. And that's a high-level rational argument. But there's already inequity built into this system with all of the exceptions and all of the requirements for farms. You're never going to get equity.
Yeah.
Everybody is already in. It's just that they're in through different avenues.
Yeah, that was where I was going with that, is trying to figure out where what made them feel like they could.
I mean,
How that was spelled out, that they can.
I think one of these towns doesn't have water lines, doesn't have sewage lines, and the only authority that they've created their utility for is the collection of stormwater. I think in St. Albans town. And so that's the only reason that to fund their MS4 permit. Then you got to look at the MS4 permit. The MS4 permit says it doesn't apply to developed lands, and the EPA rule says it doesn't apply to ag runoff. The RAPs say you can't let anything that's touching your impervious surface in your production area reach a surface water or groundwater. So,
Representative Temple?
So you may have actually already answered my question, but yesterday was the closest thing we've gotten from a contrary argument from the municipalities, and it wasn't from any legal perspective or directly from any township. So I just want to, it was a very soft response, but what the witness said was that what the farms are being charged for in this situation are the commons. So the common roads, the parks, the areas that aren't covered by private property, that the municipalities weren't actually charging farms for their farm runoff, but for their portion of the collective costs. And to go further, she also made a point that the municipal stormwater systems were receiving water from farms. So it was a bit of a contrary explanation. First, she's saying it's actually not for farm runoff, it's for commons. And then she was saying, well, but there is farm runoff and we need to pay for that.
Well, if you're going to assess for the commons, then just call it a property tax, right? Because when you look at the MS4 permit, it has an applicability section and it says it applies to developed lands or those contributions to the MS4 system. And I said, and farms are not developed lands. All farms are not developed land. And yeah, there's probably some contribution of something from a farm to an MS4 system. But again, EPA rules say that if it's coming off that field, if it's agriculture or stormwater, it's not subject to a NIPDES permit.
Right.
And an MS4 permit is a NIPDES permit.
So regarding going back though to the property tax, is property tax set up in such a way that it could assess a fee for stormwater?
Well, not the education property tax. It would have to be the municipal property tax, and that would have to be voted at the municipal level for that purpose.
Okay.
There was at one time, and I haven't been able to find it. There was at one time a town that just included like $1 on everybody's property tax for stormwater. I think it was Essex, one of the Essexes.
So they've done this.
And yeah, it's been done like that before.
John?
Just to follow up on Dave's question. So when towns had authority to create these utilities, are the utilities then free to assess, if they were covering, saying like water runs on the common roads, everybody has to pay their fair share. Can they do it as impervious surfaces? Can they do it as a property tax? Can they do it as acreage? Can they, and then do they have that sort of flexibility? Like, one of the parcel farms on the Interrail said they managed to get their fee reduced by half, but none of the other parcels there have done that. And so we were wondering about something like UVM. A lot of impervious surfaces say they have to pay their share. It would be an enormous bill, but I assume they probably have negotiated something being a not-for-profit. But I just wondered what flexibility utilities have in statute to.
It wouldn't be in statute, it would be under their bylaw or their ordinance that created the utility and gave them the power to assess the fee. They probably, I don't know if all of them, but most of them probably have incorporated authority under that bylaw to mitigate the fee or reduce the fee when necessary, when requested. So you'd have to look at each of the different municipal authorities to figure out what specifically they allow for mitigation.
And they may be all different, right?
They could potentially be all different now. Now, as to assessing the fee, Vermont is not the only state with stormwater utilities, and the common model that's been adopted, DC, Ohio, California, across the country, is to adopt what's called an equivalent residential unit. It's basically kind of like the base fee of a base property, depending on where you're located. Like in DC, it was like a quarter acre, you know, but in other jurisdictions, it could be impervious surface on an acre. And then once that equivalent residential unit is calculated, the jurisdiction can create a formula that can be applied to most properties. Some jurisdictions treat commercial and industrial differently because they want to actually assess a fee per actual impervious surface on those properties, but they can also use an ERU formula that's specific to an industrial or commercial property. It's very specific to the jurisdiction, and it can be very specific to how they want to regulate and how much they want to collect.
What are developed areas under that? Whose jurisdiction is that? Because you mentioned farms and developed land don't fall under this MS4.
Right, so there's 5 NIPD's discharge permits, and Vermont has been delegated the authority to regulate all of them. The first is the construction general permit, when you're going to disturb it's now a half acre or more of land. You have to get a general permit coverage or sometimes an individual permit coverage, and that's usually for development. But it's not just for development. It can apply on farms as well. Then there's the direct discharge permit when you are putting in waste into a water. And that's kind of intuitive. Like, then there is the multi-sector general permit, which is a permit that industrial stormwater discharges need to obtain. And it's usually based on what industrial classification code you have. Then there's the MS4 permit, the municipal separate storm sewer permit, that generally municipalities of a certain size need to implement. And it's things like street sweeping, catch basin emptying, road practices, bridge practices. And then the 5th is really not a NIPD's permit, it's a state permit. It's the state stormwater operating permit. It's not required by the Clean Water Act, but if you are going to develop, redevelop, or what's the third term? Expand impervious surface of a half acre or more, you need to get a state operating permit, and that's an annual permit. You have to meet certain conditions for the development, expansion, redevelopment of the impervious surface and maintain that consistent with the A&R Stormwater Management Manual.
So except for the MS4, all those other 4 are administered by A&R?
All of them are administered by A&R. The only one that's not federally required is the state operating permit. But EPA has what's called oversight authority. I call it overlord authority, where any delegated state needs to meet statutory and regulatory minimums. And they can at any time say, hey, you're not meeting those minimums, including enforcement minimums. And then they can come in and say, hey, you need to do something different, or we're going to enforce this because you're not enforcing this. And so they're the big brother. And the threat that everyone uses is that if you don't comply, we're going to have EPA de-delegate you the entire state or just one program. You know, I've heard that threat since I've been here. Honestly, it was really only viable around the time of the Lake Champlain TMDL disapproval, and whether or not the state wanted to take on all of the things it took on in order to come into compliance with that. And it did a lot. That was a philosophical, policy decision.
I mean, it seems to me that if these MS4 municipalities have gotten to the point where they're like, everybody pays for the commons, the metric we're using is impervious surfaces, then it seems unfair to farms because none of that water in the production area ever makes it.
It's not supposed to.
Yeah.
To surface water or groundwater.
You all set?
Yeah.
Representative Supranat?
I have two questions. The first one is only non-point source pollution regulated by the Agency of Agriculture and the RAPS? That's the only section of water quality the agency has jurisdiction over? And what water quality intersections do farms have to go through with DEC or ANR?
So the RAPS in statute are supposed to address non-point source pollution. When you go to the actual RAPs and its applicability, it says no farm shall have a direct discharge to state water. If you have a direct discharge, statute says that ANR DEC is the one that regulates that. Now, statute also says that the two agencies need a memorandum of understanding for how they implement that. Because under federal law, you can have a direct discharge that can stop and doesn't necessarily trigger a permit requirement. So that's where some tension arises with the agencies about when a discharge is discovered, what each agency needs to do. Does the Agency of Ag need to inform ANR right away, or can the Agency of Ag cure the discharge? That's what the MOU dictates, and that's really, to answer your question, what is that interface? That kind of directs the interface. If you've got a direct discharge, which includes over application of nutrients or manure to a field, then ANR should be getting involved, at least noticed.
And that notice would only come from the Agency of Agriculture?
Not necessarily. There can be citizen complaints that can trigger ANR's jurisdiction, or at least their enforcement response.
And thank you. And my second question is, you said that ultimately for charging this stormwater fee for the municipalities, that farmers are paying twice. What's the other, where are they also paying?
Well, they're probably paying more than twice if they're really complying with the RAPs. First, if they're an MFO and an LFO, they each have an annual permit fee. An LFO is $2,500 and an MFO is $1,500. And then if they're being assessed under the MS4, that's second. But third is what they have to do in order to prevent that stormwater, that rain, or any other liquid from leaving the production area, which requires annual maintenance of the production area. And then they have to have a nutrient management plan, which depending on the farm has to be amended at regular intervals, approved at regular intervals, and that costs money. That can cost up to $10,000. And so that's where and then if you're not going to apply your manure yourself and you're going to hire a custom applicator, then the custom applicator cost. If you're going to apply the manure yourself, you need to get certified. That's money. So that's kind of, I did a assessment of what Vermont's environmental laws generally cost a dairy farm in the state per hundredweight as opposed to other states. And it was rough, and it wasn't a perfect model, but we came out to about $1.72 per hundredweight per farm. for like an average medium farm. That costs more to a Vermont farmer than other farms in the region.
Mike, is the $1,500 or the $2,500 fee for an MFO or an LFO, is that related to stormwater somehow?
Well, the MFO and the LFO permit, the MFO permit is strictly supposed to be a non-point source pollution permit. The LFO permit started out as a land use permit and kind of morphed into a land use and non-point source pollution permit. So MFO is definitely, LFO has other considerations besides just non-point source pollution.
And those fees are paid to the state?
Annually, yeah.
Were you all set?
I'm all set.
Okay, Representative,
Good. As far
thank you. Representative Lipsky.
Mike, you've done an incredible job, but it's that these acronyms, NIFTIs. What does NIFTY, how do you spell NIFTIs and what?
So the acronym is NPDES.
BES?
Yes.
NPDES. And it means National Pollution Discharge Elimination System. Discharge Elimination System. And then complicated further, in Vermont, we call them the VIPTES permit. The Vermont Pollutant Discharge Elimination System.
Thank you. That was very helpful. I got it written down.
So can we go back to the equity part of this that was included by the Senate? It's kind of, since it was brought up by Ron about the people who didn't pay into it, it's kind of weighing on me. So I would imagine what I'm asking for is the legal perspective of fairness in this particular situation where people who are defiant and didn't pay are essentially rewarded and the people who did pay in are punished. And I'd love to put that one right. And I'm wondering what the perspective on that would be from a legal viewpoint.
Legally, there's this thing called the Common Benefits Clause. It's similar to the Equal Protection Clause under the U.S. Constitution, but it basically says that people need to be regulated and receive a common benefit and the common regulation, the negative,
The cost.
when they're similarly situated unless the state has a rational purpose for doing that. And there's a further component of that. It's the equitable assessment of taxation. Theoretically, these are taxes. They're called fees. You can call a fee a tax and a tax a fee. A court is going to be the one that's going to look and say whether or not it's one or the other. Most instances, I think stormwater utilities are assessing a fee. They are assessing for what is reaching their system. But here, you've got farms where they're not supposed to have that stuff reach the system. And then federally, it's not supposed to be regulated at all, some of it. So there are equity arguments on both sides that they never should have been assessed. But that since they were assessed, then all similarly situated should pay up until the point where you say they should not. That would be something that would meet the common benefits test.
With something else like to the level of repaying those who have paid plus interest and then not assess any back tax fees on those who didn't pay?
Yeah, so when the courts in other jurisdictions have looked at stormwater utility fees and whether or not they are a tax and a fee and whether the jurisdiction had authority to assess. And when they found that they haven't had the authority, they have required reimbursement and they have required interest on that. And it's been incredibly expensive and burdensome to those jurisdictions.
But maybe they deserve that, given that they've gone out of their authority.
Yeah, I think in some of those cases, it probably was deserved because the case I know the best is in Maine. It was a municipality that it was clearly a tax and the municipality didn't have taxation authority and they just did it and like they didn't care and it was challenged and they still did it and they didn't care. You know, these municipalities are in Vermont, they're not in that same situation. They're having these requirements imposed on them by the state, and they're in very full faith trying to comply with them. And they've taken on, through this MS4 permit, the attainment of the stormwater impaired waters, which they probably never wanted, but it was something that could be regulatorily done at the state level. So I don't think you have a similar situation to those jurisdictions like in Maine.
Because of intent?
I don't think they intended to
Abuse.
improperly assess. I think they thought, and I still think they think.
So intent legally is a metric here.
Well, it's a policy decision. It really is. And you do have some legal issues with the common benefits clause if you're not going to assess, you're not going to require payment by those that were assessed before the effective date. You summarized that pretty effectively. But your rational basis for doing that is that the municipalities didn't have authority to begin with.
We heard testimony yesterday from a farmer who said that, correct me if I'm wrong, committee, he had checked with the agency and the agency had said, no, there is no authority. And
Which agency?
Agency of Agriculture. And I may be inferring that the municipality was looped into that conversation, but I'm wondering whether in fact it's clear that municipalities did not get an opinion themselves from the agency and may have been told you can't do that, but went ahead and did it anyway. So that's an open question. I'm not sure that we have the answer to that.
I think the municipality probably wouldn't have gone to the Agency of Agriculture. They probably would have gone to the Agency of Natural Resources. And
may have been told, go ahead.
yeah, I don't know what they were told. I think there's been some discussion, maybe even disagreement about what the extent of the municipal authority is, but I just want somebody to show me the authority that a clear-cut authority that they have. I don't think their authority to charge utility rates under consolidated sewer districts is clear because they're implementing the MS4. And the MS4 doesn't apply to farm.
So the other thing that this witness yesterday mentioned, farmer, was that his farm in the Intervale was sort of down, not upstream, I guess, of the system. And so he questioned, even if he weren't a farm, water, any water, stormwater that might be discharged from his farm wouldn't flow into the stormwater system. And so my question, I guess, is whether because it's something you said earlier just made me wonder, are they supposed to be, is there anything saying you can or you can't assess a fee on property that isn't actually upstream of the system?
No, there's nothing like that. The applicability and the exemptions don't apply in that way. It just says certain things are exempt, and then it says even if it's not typical stormwater, we're gonna regulate these things. Or we're gonna exempt these things, like irrigation flow. They say that they, under the MS4, they're gonna regulate irrigation flow. Because that's not technically ag stormwater. It's, but there's so little irrigation flow in these MS4 communities. I mean, there might be some in Colchester, maybe a little in St. Albans, but otherwise, no.
And then my last question, I think, can you explain to the extent that you understand what the AOT's arrangement is? And does that tie into this question of the commons and roads being impervious surfaces that also need to be assessed a fee?
Sure. So a few years ago, the Agency of Transportation, they also said we should be exempt from these municipal fees. They were being assessed not on state roads, but on state properties. And sometimes the interface with state roads and municipal roads, because of how the infrastructure, the enhancements were built, typically around roads and bridges.
Or like an airport?
Pardon?
An airport?
This was really about highways. It wasn't about airports. And the AOT was making pretty good arguments. First, they have what's called the TS4 permit, the transportation storm sewer separate system, which is a state permit for how they're supposed to regulate stormwater off of state roads and state infrastructure. And there's a ton of requirements under that, and they're pretty good in complying with that. And then they were saying, well, we accept stormwater from municipal lands, private and public, run into our system, and we have to control that. And we're not getting any benefit from that. And so they said they shouldn't be charged twice for A, complying with the TS4, and then B, any municipal assessment. So what, as a compromise, underneath the municipal sewer authorities, there's a provision in each of those authorities that says when the authority is assessed against state highways, that the state highways and infrastructure, that the AOT gets a 35% offset of the fee.
Not seeing any other questions. Yeah, John.
So was that similar argument then also that they had to pay into the commons just like everybody else?
That commons argument is similar. What the TS4 didn't have is this federal law that says, or state law that says, hey, your stormwater should never reach any system, even the ground. And even when you're outside your production area, a federal law that says it's not subject to a permit. Plus the state permit says developed lands aren't farm. You know, it's just like, they didn't have those arguments. And the farms have those arguments.
Let's take one more question, Representative.
Just really quick, I want to loop back to how do we deal with the farms that have been assessed a fee this fiscal year and they haven't paid it? And I just wonder if we need to clarify that. Or do we just sort of assume that by the time this is all done, the fiscal year will be in a new fiscal year?
I think maybe unless you have something new to add. I think maybe we should save that for conversation.
Okay,
Yeah, I think it's item one,
okay.
list of what we do next.
But I would make one point, municipal fiscal years are not the same as state fiscal years.
Oh,
So you'd have to take that into account as well.
okay.
Some of them,
Ours are,
some of them might be July to June, but others might be calendar year.
Right? It depends on when they adopted their budget.
Can we just get some clarity too, and maybe not from you, but around how many farms we're talking about that haven't paid? Is it just one fiscal year, or are there farms that have been sort of protesting in this payment for, you know?
It's been for a period of years, but not that many years.
I only have heard of one that said they're not paying, and I thought it was a more recent claim, but I'm not sure. I don't think it's a large number at all.
All right, well, I think we will stop there, and a little later this morning, we will have some testimony from one of the municipalities, and we'll be able to dig into that and maybe find out, you know, from that particular municipality whether they've been getting payments or not. And I think we'll ask Mike to come back later to go into Title 10. Just because we have another witness at 10 o'clock and we should take a little break. And this will take longer than we've got right now really to do justice to. So we'll check and see if you're available later today when we have time. And if not today,
Okay.
sometime tomorrow perhaps. Thank you for that. Let's take a short break, committee, and be back